Welcome back, everyone, to Relate Humanly. I am Rob Nuttleman, employment attorney, mediator, and public speaker. We're joined again today by my fearless paralegal, Sophia Freyer. She's got a
Yeah.
couple of different questions that we're going to go through, some queries that have come by that we thought might be useful. So sit back, grab a cup of whatever you like to drink, and let's get started. Welcome back, Sophia. How have you
Thanks for
been?
having me. Oh, delightful. Just talking about some artwork that I might put up in my office and things of that nature.
I noticed that the wall behind you is blank, but I know that not all of your walls are blank.
No, not
So
all the walls are blank, but
those who actually come
making
in,
decisions.
those who actually get to come in and actually see you in person can see some of your wondrous artwork. So that's
True.
wonderful.
True, true, true. Okay.
Um, so we got a couple of different questions that come
Yes.
out of that you brought up, some scenarios to bring up. So
Yeah.
what's the
So
first one we got?
the first one is the co-owner of a company was accused of a sexually inappropriate conversation with an employee, and the employee reported the conversation to the other owner. But right before the employee reported the conversation, there were performance issues noted coming from one of her colleagues.
Hmm.
And the co-owner is pushing for her termination, or at least a PIP to be put in place. And a PIP is a performance improvement plan to address the performance issues. And what things does the company need to consider in this scenario?
Okay, so one co-owner gets a report from an employee that the other co-owner engaged in some sexual harassment of some sort.
Mhm.
Just prior to that report coming in, there were issues that were raised regarding the employee's performance. Do we know if those issues were raised with the employee before or after the report?
It doesn't say, and it doesn't say if any of those issues were recurring or if this was just a one-time thing that was brought up.
Okay, so these are, quite frankly, not an unusual case
Uh-huh.
situation. So, first and foremost, we have to understand that an employer has an obligation to maintain an harassment free work environment. And if an employer becomes aware of sexual harassment or possible harassment, it triggers an obligation by the employer to do an investigation. So first and foremost, whoever received the complaint should say, "Hey, tell the employee, look, this is important. Thank you for bringing this to our attention. We need to get some more information and we need to investigate this." From there, there's a couple of different paths. One is, do they do the investigation internally, or do they have an outside person do the investigation? I think it is usually better to have an independent third person do the
Uh-huh.
investigation, particularly when the person who's being accused of the harassment is an owner, a co-owner,
Yeah,
because ultimately whoever is within the organization is going to report to that owner,
right.
and we want that to be as unbiased an
Mhm.
investigation as possible.
And really quick, Rob, who would you recommend for outside sources to go to for such
Yeah.
investigations?
So there's a lot of really great investigators that I've used in the past. One that was on the podcast, Kara Trapani with Trapani Bueller. It's an excellent investigator. She has a colleague, Lena, that I'm hoping to get on the podcast soon. I've used some other attorneys. Janine DeBacher is a great one over at McFarland Sprinkles. And then Michelle Reinglass also is a wonderful investigator. And these are just a couple of names that I've referred people to. And what I'm
Mhm.
looking for in an investigator is somebody that is absolutely neutral. The law does limit who can do those investigations.
Yeah.
If the investigation is done by an employee, it really can be done by anybody from a legal perspective, not necessarily from a practical perspective. If it's going to be conducted, and specifically, we're talking about a investigation regarding sexual harassment.
Mhm.
If it's going to be conducted by somebody outside the firm, it either has to be done by a private investigator or it has to be done by an attorney who's licensed to practice law. I'm still not exactly sure why that's what the legislature passed probably about 2 decades ago now, but it is what it is. So those people I mentioned, they are all attorneys that have experience with Title IX investigations and workplace investigations. Bringing in that investigator adds credibility, and enables the company to ensure that they do an adequate investigation.
Yeah.
One of the things people use that word harassment very frequently, and we want to make sure we understand what that really
Yeah.
means. So maybe before we bring in the investigator, the co-owner who received the complaint should say, "Oh, tell me about what is it that happened," just to get a sense. Because if it is truly sexual harassment, comments of a sexual nature,
Mhm.
or treating somebody differently based on some protected characteristics such as gender, then absolutely we're going to want this outside investigator. If, on the other hand, maybe the harassment is this supervisor, this owner is telling me that I didn't do a good job and is wants to put me on a performance improvement plan. That's not really harassment as the law defines it,
Mhm.
although there are circumstances where that could be a basis or part of a harassment claim. So,
Mhm.
getting that initial assessment is this truly sexual harassment where we need to bring out an investigator is a good idea. Making sure we let the person know we're taking the matter seriously.
Seriously.
Um, obviously you've done a lot of handbooks, you've written anti-harassment policies, you
Mhm.
review them, and in those policies it says certain things of what's going to happen. We're going to do the
Yeah.
investigation promptly. We're going to keep
Yeah.
things confidential to the extent we can. We can't
Mhm.
guarantee complete anonymity. There will be no retaliation for somebody bringing a complaint, even if it's
Yeah.
determined that the complaint later we're not able to sustain it. And those things
Mhm.
are important to communicate to anybody who's reporting the harassment. And that reporting person might be the victim or it might be somebody who observed it. So
Yeah.
just when I say complainant, I actually prefer the word the person who made the report because it may or may not be the one who's actually the one
Yeah.
experiencing it. As far as addressing the performance issues, I would need a little bit more information. We're gonna have to
Yeah.
determine, is this something we've already had in the works and the
Right.
employee knew about? Sometimes employees may make an allegation of harassment because a supervisor or a manager is trying to get the employee to perform.
Mhm.
And they may, whether that's as a defense mechanism or it's a more of a, well, as long as we're going to get everything out there, I want to let everybody know exactly what I've been experiencing. Either
Mhm.
way, we have to take it seriously and we have to address those issues.
Yeah.
I would, certainly in the investigation, the fact that there are performance issues is probably going to come out.
Mhm.
I would not make any immediate decisions regarding performance improvement
Yeah.
until we really finalize what is this harassment issue and is this something we need to do. So if this is my client asking, can we put this person on a performance improvement plan? I would be telling them more likely not, let's put a pin in it, let's get
Yeah.
more information, let's make sure we take care of our legal obligation on doing the investigation and coming to a conclusion as to whether or not there's something unlawful or untoward happening. And then we'll have to decide how and what is the best way to address the performance issues. We don't want to ignore performance problems, but we also don't want to make it look like we are
Yeah.
making a big deal of something because the employee made the complaint.
Yeah. And then obviously a termination in that scenario would be not the right move, but could you speak a little bit more towards why performance improvement plans really raise feathers on employees and why they actually make it far likely in many scenarios for an employee to seek an attorney?
Yeah. So, and I've said this many times,
Mm.
the number one reason employees come to see an employment attorney such as myself is because they believe they've been treated unfairly. And
Yeah.
it is human nature when things follow chronologically that people assign causation. Sometimes that is an accurate assessment that A, B, C means that A caused B, B's caused C. Other times they just happen to be temporally, they're connected chronologically, but there's no other real connection. I might have been ready to fire you today, and you showed up in the office and you have a complaint about something, but in your brain, you're going to connect those two as being connected. So
Yeah.
if I proceed with whether it's a firing or performance improvement plan or any other kind of what could be considered retaliation, in your brain, it's more likely you're going to go talk to an attorney.
Yeah.
Even if there's no violation of the law, it's going to create a rift. It's going to be much more difficult for me to address. Like, as the employer, I want to address your performance issues. Well, if you're in a position of Rob's only doing this because I made this complaint, you're not going to take in the information that I'm giving you about how I want you to improve. So it's going to be counterproductive in the first place.
Mhm.
So we're always needing to be cautious and aware of how people might perceive accurately or inaccurately what is my motivation for doing something.
Yeah.
And retaliation is not limited to uh, terminating somebody. It could be suspending them. It could be lowering their pay, not giving
Yeah.
them a raise. It's any way that you would, if you treat somebody differently because they have reported harassment, safety violations, workplace issues, certain workplace issues, employers cannot retaliate against that individual and they can be liable for lost wages, lost income, um, attorney's fees, sometimes for some pretty severe penalties under Labor Code 1102.5.
Mhm.
So, whenever I'm talking with an employer about disciplinary action, we're asking questions about, well, has that person recently raised any issues regarding certain types of protected conduct?
Yeah. Yeah. All right. Next scenario, if you're ready.
Scenario number two, lay it on me. Let's hear it.
So, a company is a subcontractor on a job. An employee was diagnosed with an illness and made HR aware, as well as their immediate supervisor, and let the company know that they might need to take extensive time off in the future. The employee also felt obligated to tell the superintendent at the job site the nature of their illness. The superintendent works for the contractor, not the subcontractor. The employee believed the health information would remain confidential, but recently learned that other employees in both agencies are now aware of the illness. What course of actions should the subcontractor take, if any?
Oh, okay. So we have subcontractor as the employer, and we have employee
Mhm,
who has a medical issue. The
mhm,
employee discloses the information to their employer. The
mhm.
employee also discloses the information to the prime contractor, who is not the employee's employer.
Yes.
And when the employee disclosed that to the prime contractor, it was under the belief that the prime contractor would not disclose anything about the medical information. Yet that information gets somehow spread around, and now the employee is concerned. What should the employer do? Did I summarize that correctly?
Correct. Very.
So, couple of different issues that come up. Immediately, people start thinking HIPAA. I don't know that HIPAA really applies. HIPAA is a
Yeah.
Health Information Portability Protection Act or something like that.
Sure.
um, that really
Bless you.
applies to companies in the medical industry, my doctor or my doctor's office or healthcare facilities, things like that.
Mhm.
Um, I'm not saying it doesn't impacted, but HIPAA is not my particular area of expertise. So, certainly if somebody's an expert on that area, hit me up in the comments and feel
Sure.
free to correct me on that. But there is something called COMIA, the Confidentiality of Medical Information Act, as well as the requirements under both state and federal disability discrimination laws. Under all those laws, employers have an obligation to maintain the confidentiality of medical information. In fact, if you give me a doctor's note, that should not go in your personnel file. That should go
Mhm.
in its own separate medical file,
Hmm.
preferably under lock and key.
Mhm.
If it is provided electronically, it should be in a separate file that's not accessible by other people. So either
Mhm.
a file that's not, it's not everybody doesn't have access to it. The main rule is we want to limit the number of people who have information or knowledge about somebody's medical condition to only those that have a need to know. So certainly human resources or whomever is in charge of handling benefits, administering leaves of absences need to know, possibly even the supervisor. That doesn't mean the supervisor needs to know the details. So if you disclose to me that, Rob, I've been diagnosed with cancer
Mhm.
and I may need to take time off of work, I mean, as the HR person, I may need to let the supervisor know, hey, just want to let you know your employees indicated they've got some medical issues that may come up and they may need to take time off of work.
Mhm.
But I'm not actually disclosing the diagnosis. I'm just saying they may need that
Sure.
time. I would follow that up with, this is not a matter that should be discussed outside of those who have a need to know. So
Mhm.
if you feel the need to bring anybody into this conversation, bring it to me. So you're instructing the supervisor not to have that conversation. You're saying, I'm just letting you know this so that we can work together to make sure we provide that time off.
Mhm.
What do we do in the disclosures to somebody outside the company?
Yeah.
Well, first of all, I would probably as a subcontractor, reach out to whoever is my contact person at the prime contractor and say, hey, look, we've had an issue. We understand our employees disclose certain medical information to this one employee, and that has gone to the superintendent, and that
Mhm.
information's gone beyond that person. We need to make sure that that stops. Both you as the prime contractor and us as a subcontractor have an obligation to maintain the confidentiality of medical information. So let's work together to figure out how do we make sure that there's no further discussion. And it might be as simple as having the conversation with the superintendent of, hey, this is this is what the law requires. We can't disclose that. Please let us know to whom else you've discussed this information or you've disclosed this information so that we can somebody, hopefully the prime contractor, will let everybody know, hey, people's medical information is their own private information. We don't discuss that. We don't disclose it. If you're doing so, please stop. At
Mhm.
least put a stop to that. And we want to let the employee know
Yeah.
that, hey, we've done this. Um, what do you think about it? Do you think we should talk to the employee first, let them know, hey, this is what we're going to do? Or should we just do it?
I think it probably depends on the demeanor of the employee, but I think the safest bet would be to talk to the employee first and say, here's the proactive steps that we're going to take. Does this sound like something that would be beneficial to you? Because we think that's the best course of action or something of that nature. But I don't know. If it's severe and it's something that should get handled very quickly, then I don't know.
Yeah, I mean, based on the limited facts we have, right?
Yeah.
I agree with you. I think the best thing would be when the employee tells us, best response is, hey, thank you for bringing it up.
Yeah.
We take this matter seriously. Your medical information is confidential and you get to decide who gets to know it. Our policy is, we only disclose it to persons that we have a need to know. We can only control us, but here's what
Yeah.
we'd like to do so we can communicate that to the company over there, which is
Sure.
uh, obviously we can't just reach out to the superintendent. It's not our employee. So I need to talk to our contact person just to let them know we need to have a conversation with the superintendent. We will not
Mhm.
disclose your medical condition. Just the fact that you had a conversation with them about some confidential medical information, it seems that has gotten out and we need to make sure we contain that. Is that all right
Sure.
with you?
Yeah.
Hopefully they say yes. If they say no, I don't want you to do anything. I don't want you to say anything. Then what do we do? Let's say they say,
Oof.
no, absolutely do not talk to them about it. I don't want you to.
Hmm. I don't it's hard because the employee is the one who brought up the issue with the superintendent. I don't know.
Well, it, I don't know if there is a clear answer.
Yeah.
On the one hand, we want to respect the employee's wishes. And
Right.
we actually do see this more frequently in like a sexual harassment case where
Mhm.
employee comes to HR or a supervisor
Yeah.
or a coworker and says, hey, this has happened, but I just need to tell you and I don't want you to do anything about it. That's a slightly different situation because
Yeah.
we have an obligation,
Obligation.
yeah, to do the investigation and make sure there's no harassment.
Mhm.
We don't have an obligation to ensure
Right.
some third party employer isn't disclosing medical information. Now, if the employee came to us and said, hey, I'm being sexually harassed by this superintendent, we would have that
Different story.
obligation.
Yeah.
So I would say in this situation, I would probably respect their wishes. I would say,
Mhm.
look, we can do that. Our preference would be to at least have a conversation with them so we can contain it. But if you're
Mhm,
telling us that that's what you want us to do, that's what we would do. And then I
mhm.
would confirm that in writing. Hey, you brought this to our
Yeah,
attention. This, wasn't something that happened to us. As a result of you disclosing this to other people, you've asked us, we've told you we want to do this. You've said you don't want us to take any action. If that ever changes, let us know.
yeah. And
In
would
the
you recommend
meantime, we do
having
recommend,
yeah,
hey, you as the employee, that you go to the superintendent, say, hey, I share that with you in confidence. Please don't discuss that with other people, so
sure,
that it doesn't, so at least it stops it going forward.
yeah. Would you recommend a follow-up conversation with the employee a few weeks after? Just like if the employee said, "No, I'd really rather you not say anything." Or would you
I,
recommend it just kinda letting it
I
lie
do
after
like follow
saying
ups. I mean, if we,
yes.
employers are so inundated with many different things, it sometimes is
Right.
hard to remember to do that. But if you put on, a little tickle on your calendar that says, hey, in 2 weeks, reach back out to Sophia and ask, hey, just want to see how things are going. I know we
Yeah.
addressed this issue. Is there anything you want us to do differently? It's showing that you care. It's showing that you're
It's in
being
writing.
responsible. Yeah. And it's showing that you're being responsible and
Yeah,
responsive, um, so that
totally.
you're putting their needs first. That's a great idea.
Yeah, okay, cool.
So what's
Next,
any others we have for today?
there's one more. It's very short, but I think you will have a very long answer, which is typical,
Just
but
so we know, no matter how short or long it is, I always have a long answer, but okay.
a company is considering switching from a defined vacation policy to an unlimited PTO program. What things should the company consider when deciding? For our listeners, Rob just put his head in his hands when deciding whether and how to make the change.
Yeah, so yes, my head was in my hands because I am not a fan of unlimited. You can't see my air quotes unless you watch the
Hmm.
video. Unlimited PTO policies or unlimited time off. And there's a couple of reasons why. So
Yeah.
let's go back years and years.
Yes.
Under California law, vacation is a wage, and it, according to the labor commissioner, and I think it's the Suastez case,
Mm.
Suastez,
Swastas. Yes.
says that it is a wage that accrues over time. So if I give you 80 hours of vacation per year, every day or every paycheck or every work week, depending on how we've defined it, you accrue a small amount towards that. And
Mhm.
since it is a wage, I have to pay that wage out at the end of your employment. So 6 months into your employment, you quit or you're fired, you haven't taken any vacation, you've earned half of your year's worth of vacation. I have to pay that out with your final paycheck. If I don't, there's all sorts of
Yeah.
penalties. Employers have tried all sorts of different ways to kind of get around that. Most of them have been rejected. One method is, oh, you don't accrue any vacation during the first 6 months, and then we're just going to give you a flat. We're going to give you 1 week at the end of 6 months. Labor commissioner said, no, that is
Yeah.
really accruing over time, even though you're not letting them use it. And there are some opinions as far as how much, you do have to let it carry over. So you can't have a use it or lose it policy. Use it or lose it
Yeah.
policy says you get 80 hours, you didn't use it in 2026, we're going in 2027, you don't get to use it. Nope. Not only does it have to roll over, you have to continue to accrue vacation until you can set a maximum limit. Labor commissioner opinion letters say a 2x limit. So if you get
Hmm.
80 hours in a year, you can accrue up to 160. That's a valid limit.
Hmm.
I don't know any magic reason why 2x would be what it has to be. It could be 1.5x, could be 3x, but so take those into consideration. The more recent one that people have done, God, you're right. I am just going waxing poetic on this one, but
Hmm.
it's one that sticks in my craw. The more
Yeah.
recent thing is some companies start off in high tech industries, as far as I know, said, you know what? We're not going to track vacation. If you need to take time off, you take it off. If you don't, this is going to be more convenient. That way you as the employee get to decide on your work life balance. And so there's no vacation, but you can just take it time off when you want it.
Bad. Very bad.
Case came up where there was this unlimited PTO policy for executives.
Yeah.
And I think it was like a C-level employee and worked there for like 4 years and left and is like, hey, I want to get paid out my vacation. Now, mind you, states outside of California, many of them, you don't have to pay out vacation. This is somewhat California
Mhm.
specific, or other
Yeah.
states have
Totally.
similar laws to California. And the court said, well, examine the company's policy, and it wasn't really an unlimited policy because the employee couldn't take off as much time as they wanted. If the employee said, you know what, I might take the next 3 months off with pay,
Let's say no.
the company's going to say,
Yeah.
no, you can't do that. We need you to be here. So there are limits. They're just not limits that we're telling anybody what they are.
Yeah.
Um, so in that particular case, the court said, well, we're going to, since this isn't unlimited, there are limits, but you haven't defined a limit. So we're going to look at what would be a limit typical for somebody in this type of a job. And I think they said it like 4 weeks.
Mhm.
And well, you worked for 4 weeks, you worked for 4 years, 4 years times 4 weeks. That's 16 weeks of vacation that you had accrued. And even though you had taken some time off, since there's no record of when you took the time off, we're going to have to you have to pay that out, as well
Yeah.
as the penalties that accrue with that. And so it can get very expensive. Now, and there's two main reasons that employers that I've seen want to use this unlimited policy. One, they believe that, hey, it's more equitable. We wanted people to make their choices. And two, they're tired of this whole nitpicking, counting the hours, counting this. And
Calculation.
it's an administrative nightmare. And we just don't want to have to do that. Maybe some of them, part of that is we don't want to have that liability because
Mhm.
accrued vacation is a liability against their books. It's a red mark because it's money that is owed. Studies have found as to that first one that, hey, I want to take the time off. I want people to have a good work-life balance. People take less time off with an unlimited PTO policy than they do with a defined because they
Mm.
never know how much is too much.
Right.
So you're not achieving the goal of giving them a better life work balance. If you want them to have a good life work balance, give them a defined
Make it
period,
clear.
2 weeks, 3 weeks. Let them take that time off.
Yeah.
As far as the second, we want to avoid that red mark, or we don't want to have to go through the administrative nightmare. You're not getting rid of that under this particular case. What you're doing
Yeah.
is you're just
Making it
forestalling it,
unknown to
and
yourself. Yeah.
exactly, and you're making it so that a court or an arbitrator or the
Can
labor
decide for
commissioner is
you.
going to decide how much vacation you have to pay out
Yeah.
as opposed to having a defined plan.
Yeah. One other thing, and it's specific to California for sure, it's kind of how that unlimited quote unquote policy would interact with paid sick leave or SIFRA or FMLA leave. There's a lot of different things there that I think are worth speaking about too.
Yeah. So I had a client one time that had an unlimited paid sick leave policy, which is very
Yeah.
generous. Or nice of them to do this. The problem was under the law, under California law, employees, if I become pregnant, which aside from being a fabulous miracle,
Mhm.
um, it means that if I am disabled as a result of pregnancy, my employer has to allow me to take up to 4 months of time off for that pregnancy
Mhm.
while I'm disabled. Although it is unpaid, I'm allowed to use my paid sick leave.
Mm.
Since I have unlimited paid sick leave, this employee got to take 4 months of paid time off while they were unable to do their job. That's a pretty
Yeah.
significant financial hardship.
Yeah.
Additionally, after I give birth, again, amazing miracle, uh, I can take up to
Mhm.
12 weeks of unpaid time off to bond with my child. Again, it's unpaid, but I'm allowed to use my paid sick leave. So that employee then got an additional 12 weeks. So essentially, they had 7 months off of paid time off that the employer had to pay, not only having to pay somebody else to do that
Mhm.
employee's job, but to pay the employee their full salary and cover their full benefits during that time.
Yeah.
So the same thing would apply for unlimited PTO because an employee can choose to use their vacation or PTO time. So if they want to take that time off, you're looking at potentially paying them for that time. And I've seen some employers try to minimize it. So it's an unlimited PTO, but you cannot take off more than 7 consecutive workdays.
Mhm.
So it's putting a limit not on the amount. So I could technically work 7 days, come back for 1 day, work 7 days, come back for 1 day.
Mhm.
Um, Maybe. I think that's fraught with problems, and we don't know how the courts are going to look at that. Are
Mhm.
they going to look at that? Oh, that's a way just to discriminate against people who are taking protected leave. It's not, because it would apply
Mhm.
to any leave, whether you're taking off to go to Disneyland or because you're
Yeah.
having a kidney replacement. So I look at all those with caution. And my recommendation is don't do it. Have a defined plan.
Yeah.
If you want to allow people to go in the red, like, okay, yes, you only get 2 weeks per year. Oh, you want to take off an extra week? No worries. We'll let you go in the red. Okay. We'll advance you that. Okay. Or you let them take the time off, and the time off is without pay.
Mhm.
Uh,
Yeah.
there's a whole other issues with vacation time about, well, what if, and we'll say this for another
Yeah.
podcast. What if I'm on vacation and I look at my email?
Ah.
And that's a whole nother issue that we can unpack
Yeah.
on another occasion.
Yes.
Any other issues that we want to go through today?
I don't think so. I think that pretty much covers it.
Okay. Well, thank you, Sophia. These are great questions.
Thank you.
If you, as a listener, have questions, feel free to reach out at nuttleman.com. Feel free to submit comments, hit that like button or the subscribe button. Tell a friend. Hopefully, you're finding this information useful. If there are particular topics that you want us to cover, like I said, contact us at nuttleman.com. If you have a guest that you think would be appropriate to come onto the podcast to talk a little about human relations, issues within the workplace, conflict resolution, communication issues, we're always open to having good conversations with people and professionals in the industry. So with that, everybody, have a wonderful day. Sophia, thanks for your time.
Thank you.
Have a good day.